Morning, everyone. My name is Amy. I am the Vice President of Recruiting here at Worldwide HealthStaff. I am joined this morning by Gregory Bolt, one of our immigration attorneys, and Jesse Analakai, who is our campus recruiter and our OPT specialist. And today we're going to talk about the immigration options that you have right now. We're going to hear from Greg, who is an expert, and we also are going to be able to take your questions at the end. So if you have questions this morning, please put them in the chat or the Q&A section, and we would love to take your questions. We'd also love to hear where you're watching from. So, or if you're attending a university, what university you're attending. So welcome, everybody, and I'm going to turn it over to Greg.
Thank you, Amy. I appreciate it. In terms of what we'll start with today is really what's impactful for many individuals that proceed through the immigration process in the United States, and that is visa retrogression. And the question becomes, what is visa retrogression? And this stems from the fact that there are only a certain number of employment-based immigrant visas that are available each year that individuals can utilize to immigrate to the United States to obtain a green card. And this is something that is controlled and set by the United States Congress. The United States Congress has the authority to make the laws regarding immigration and the processes in the United States, and they have set firm caps as to the number of individuals that can immigrate to the United States in many categories, including employment-based immigrant visa categories. In this regard, the situation generally is that in many instances, there are more individuals seeking these immigrant visas, seeking green cards in the United States than there are visas that have been allocated by the United States Congress. And what this creates, in effect, is a backlog. You have more individuals seeking visas, not enough visas available, and this, in effect, creates a de facto line of individuals waiting to get to the front of the line to have that visa availability. Now, in terms of looking at this, there are about 140,000 employment-based immigrant visas available each year. And these are broken down into the different employment-based immigrant visa categories, EB1, EB2, EB3. And it's also broken further down in terms of the country of birth of the individual seeking the immigrant visa to the United States. At present, the situation that we're dealing with is one of those circumstances where we're well into the U.S. government's fiscal year and they are running low on visas that are available. So the U.S. government's fiscal year runs from October 1st to September 30th of the following year. So considering that October 1st was the start of the government's fiscal year for this period, we're well into that period. And what we've faced with the visa bulletin now is that the U.S. government, specifically the Department of State, which controls the release of these visas, has slowed down considerably what they're doing with the issuance of these visas out of concern that there will not be enough to reach September 30th. And what this creates, again, is simply a line. And the impact is that individuals that are stuck, in effect, as a result of this, are not able to either apply for an immigrant visa, apply for adjustment of status in the United States, or if they've done so, for the Department of State to issue an immigrant visa or for U.S. Citizenship and Immigration Services here in the United States to grant adjustment of status. This is something at present that's impactful for everyone from every country, for example, in the EB3 category, the employment-based third preference category, which is the category that you're going to principally see, for example, registered nurses fall in. What this will do is, in effect, create delays in terms of the ability, again, to file for a green card. But again, if you're already in the process of whether it's for an immigrant visa abroad or through the adjustment of status process in the United States, it's going to, in fact, put a hold on the case in terms of the U.S. government being able to finalize any sort of application until there's a visa available. And there are cutoff dates. They publish this on the Visa Bulletin, which is available monthly. It's released around the third week of each month. and it is published by the Department of State on its website, and it can be viewed. And this specifically designates by country and by visa category the priority dates that are available. Anything on or before the priority date listed on the visa bulletin is actionable, meaning that a visa could be issued or an application could be submitted. But anything after that, it is simply not going to be able to proceed at this time. So what this creates is a situation where, in many instances, the ability to file or the ability to move forward with a case is placed on hold. And this is something that's probably going to be impactful. Again, it's difficult to predict. People try to predict this, but it's difficult to predict. But in all likelihood, when you see these types of scenarios historically, this is something that's probably going to linger into the government's next fiscal year, which would be beginning on October 1st of this year, October 1st, 2023. So, moving forward, who is affected by retrogression? As I mentioned earlier, this is something that it's really going to depend upon the date that you file. And these dates can fluctuate month to month in terms of your priority date. The priority date is going to be one of two dates. It's going to be the date that a permanent employment labor certification is filed with the Department of Labor, or for registered nurses, for example, Schedule A registered nurses, it's going to be the date that the Form I-140, the employment-based immigrant visa petition, is filed with Citizenship and Immigration Services. And that's the establishment of the priority date, which in effect reserves your place in line, that line to have a visa available. And again, that's what would be needed to action a case. And so currently, candidates are across the board affected. For example, in the EB3 category, that's the category that's principally utilized for registered nurses. It's across the board at this point in time. And again, it's something likely to remain that situation for the immediate future. And again, also, it's very difficult to predict when that might be resolved. And a lot of people attempt to predict it, but it's a very, very difficult ask to attempt to predict what could happen with visa numbers moving forward. And that naturally brings us to looking what it looks like moving forward. And once again, this is something where it's being monitored. Obviously, the visa bulletin is being monitored. We hope that it may creep forward, but the problem with the visa bulletin is that it could actually not only freeze, but in some instances, it can retrogress to the point where it moves backwards. And this happens with some frequency over time. There's a natural inclination that this is going to move forward always, but unfortunately, that's not the case. There can be months where these categories, these employment-based categories, can freeze and not move at all. And again, there are some instances where they can actually move backwards. And this is something that's closely monitored and is watched very carefully. And it's something that we always encourage everyone involved in the process to monitor as well. Again, it's difficult to predict, but at the end of the day, this keeps everybody in the loop and in effect and mindful. And it's a good way to learn and monitor about the process itself, going through it and moving forward. And it also is very, very critical in terms of what we do for planning and affording strategic and tactical advice more broadly, but again, with the tactical level, even for individual cases. Retrogression, it's going to have impacts individually for those, for example, that are seeking adjustment of status. The problem is if you're moving forward with the adjustment of status, and you do not have a prior case, for example, or an I-140 has not been filed in your case, and the priority date is not available, it becomes an issue of not being able to file an application for adjustment of status. Now, facts are unique to every single individual case, but really this goes back to why retrogression is so impactful, because it precludes individuals who, under normal circumstances, under non-retrogression circumstances, would be able to potentially apply for their green card, for example, based upon adjustment of status if they're otherwise qualified. And this naturally loops into the OPT process because a lot of individuals will come to the United States, they'll study, they'll obtain their degree, and then they'll move forward with an OPT, an optional practical training employment authorization document for 1 year after they graduate, with the idea of moving forward with an application for adjustment of status, being able to establish an employment opportunity with an employer that's willing to move forward with an adjustment of status case, with an employment-based immigrant visa case, and being able to move forward with that process and proceed with the green card application while in OPT EAD status. And the challenge there is that for most individuals, you're going to be capped on the OPT EAD for a period of 1 year. And if it takes time, for example, to prepare and file the application for adjustment of status with the corresponding employment-based immigrant visa petition and apply for a new employment authorization document based upon that application for adjustment of status to ensure that there's continuing employment authorization beyond the OPT-EAD, this can become challenging given the types of processing times that the U.S. government exhibits. And especially if you're further along in the OPT-EAD validity period when you start this process. But even if it's early on in the process, if you're dealing with retrogression that's going to be in place for months and months and months, it can be impactful in terms of moving forward with that Form I-485, that application for adjustment of status, or the corresponding Form I-765 for the employment authorization document. So where this pops up and becomes a critical question and an issue is often in this sort of circumstance where there's that 1 year OPT-EAD period that's being utilized as a bridge, in effect, to not only gain the experience and to work in the United States, but to set oneself up for taking that next step and actually obtaining a green card. And this becomes a challenge because, again, it's difficult to predict what's going to happen with the visa bulletin. It's difficult to predict month to month what those important dates are and when action can be taken on an individual's case. And so this becomes a very, very crucial element in terms of monitoring, watching, and trying to judge what can be done and what the potential timelines are going to be, and whether this can be accomplished and what challenges can be faced moving forward, knowing that there is this certain level of uncertainty in the process itself. And that pretty much covers going through what we're looking at right now. It's a very challenging period of time, for sure. For a lot of people, there are questions, there are concerns, and for many, frustrations, especially for those that have been moving forward with the process that now suddenly face a period of time where there's, in effect, a pause. And this is common with the immigration law in the United States and the processes associated with individuals obtaining immigration benefits of any kind, especially a green card, that often it is a case of hurry up and wait, and that level of uncertainty. And the fact that in many instances, it's difficult even for those that are professionals in this field and work with these cases on a day-to-day basis to give firm estimates in terms of what processes are going to look like, especially in terms of timelines, because of this certain unheralded, although quite visible now, issue in terms of there can potentially be instances where there are simply delays that are candidly outside of everyone's control in this process.
Awesome. Well, thank you, Greg. We do have a few questions here that I can go ahead and just ask from a few individuals here today. But before I do that, I did want to mention, if you are close to graduation and you're looking into options, I'm the campus recruiter. I'm the recruiter for F1 candidates. So feel free to go ahead and look at our website, and I will also put in my email and reach out to me. We'd be more than happy to share with you what our processes look like currently for retrogression for F1 candidates and how we can kind of assist you at this time. So guess one of the questions that I have here for you, so what if so a candidate is asking, what if my OPT is about to expire? And we're still in like around close to October and we're still like in retrogression. What would be their options?
So in terms of looking at this, obviously there's expected movement to take place with the visa bulletin on October 1, as I mentioned, due to the fact that that's the new fiscal year, new visas are released. But again, it's unpredictable in terms of what will actually transpire. But it becomes an issue when you're on OPT, you're still technically in F1 status. When you're in F1 status, it's granted for duration of status. When your OPT expires, you do have the grace period to depart from the United States. But generally, again, this adjustment of status process, if that is the goal and the target, it is a process that is going to take some time, even if there's the visa availability and the application can be made, because while there's, for example, premium processing to expedite the employment-based immigrant visa petition, there is no premium processing available that we can pay the extra fee to expedite, for example, the Form I-485, the application for adjustment of status, or an adjustment of status employment application, document application, the Form I-765. So normally what you see in these circumstances is that you see someone making efforts to maintain their F1 status, and that generally means enrolling in a new academic program in order to maintain F1 status until they can move forward and complete the adjustment of status process. Now, you do run into the issue of immigrant intent, which is generally something where an individual that's maintaining F1 status, in order to get that status, to obtain that visa or obtain a change of status in the United States, has to not have an intent to immigrate to the United States, but there is discretion on the part of Citizenship and Immigration Services in this regard, and it's often exercised favorably, so that's something that needs to be monitored. But normally what you'll see is somebody move into an additional academic program in order to maintain their F1 status until something can be devised in terms of moving forward with their ability to obtain a green card.
Awesome, thank you. So another question that I have here for you is, if somebody is close to if they graduate around October time, is it best for them to start the process during close to October to kind of see where the retrogression situation is, or would it be best to kind of start now or as soon as possible?
So in terms of filing the application, the Form I-765 for the OPT EAD, you're able to do that up to 90 days prior to graduation, as well as up to 60 days after graduation. Now, the processing times for these EADs, they do vary, they do fluctuate. It runs around several months, but it can fluctuate anywhere from like 6 weeks to candidly 3 to 4 months. One of the interesting developments as of late is that the government is offering premium processing for these Form I-765s. But that's something to be cautious about because they can suspend that at any time if they have backlogs or resourcing issues in terms of processing these. But the idea generally is to make the application as soon as you're eligible to make sure that you can get the card as soon as possible. But many people do not do that, and it also links up with the ability to obtain a job. What you don't want to have is a situation where you have that card, but you don't have the job to use it. Because one of the things you have to keep in mind with these OPT EADs is that it's valid for 1 year, but you can't have more than 90 days where you're not utilizing it for employment. Otherwise, you're in violation of your F1 status.
Awesome, thank you. I'm sure that would be very helpful. So another question that I have is, will it take longer than usual once the visa bulletin is current for will there be kind of any delays in green cards or the filing of employment authorizations once the visa bulletin is current? What are kind of the predictions that might happen there?
Well, it's interesting in the sense that it's difficult to judge, but at the same time, there's so many people that are in this situation right now that would like to proceed that can't. So normally where you see circumstances where there are multiple months in a row where there is visa retrogression, what you'll see is when the retrogression in effect is cleared up and things move forward again, you will see a larger than average for any particular month number of applications or petitions, simply given the fact that there's a backlog of individuals waiting to apply. But the idea in this regard is really to try to action as quickly as possible when the visa bulletin does render current for any particular priority date for eligibility, simply because you can expect in that sense generally that a lot of people will be applying. But at the same time, you look at it from the perspective that the government's not receiving the number of petitions or applications that it would normally be receiving, for example, because people can't apply. So it kind of goes both ways, and generally it balances out into a situation where it's not necessarily impactful longer term. It's just more or less a hold on taking action in the immediate period of time. But once things start up again, they generally proceed as normal.
Okay, awesome. Thank you. So I actually have another question. Let's say there is a candidate who has a spouse or is planning on getting married to a spouse that is an American citizen. And would there be any contradictions if they file for that form or a spousal green card or a family green card? Could they still then apply for, an EB3?
Yes.
What's the issue on that, I guess?
Yes, you can be the beneficiary of multiple immigrant visa petitions. You can have multiple family members petition you. As long as you're eligible, you can have a family-based immigrant visa petition, as well as an employment-based immigrant visa petition. This is something that's very common, and in many instances, people pursue this with the idea that whichever is the fastest, whichever gets done first is what I'm going to use. So there's no inherent conflict with that whatsoever.
Awesome. Thank you. Another question here that we have is, so if somebody is currently or has previously worked with another company and they have filed for, their immigration status or their I-140, let's say, could we work with them? What is kind of the situation on that?
That becomes very case specific, and we encourage anyone to reach out directly to take a look, because there are a number of variables that could come into play in that sort of circumstance, including what type of case was filed and at what stage in the process that individual is at. So a question like that is a great question. It comes up, but that's something that warrants a little bit more specific analysis rather than a general response. But I would note that in many instances, yes, that's something that definitely we can assist with.
If you are an international student that, are close to graduating, feel free to reach out to us. I'd be more than happy to answer any of your questions and kind of share what our processes are currently at this time. So thank you so much, Greg. That was very helpful.
No, thank you. It's my pleasure. And thank you, everyone, for taking the time to join today.
Thanks, Greg and Jessiana, for your insight and all of the information you shared today. As always, if you'd like to follow Worldwide HealthStaff, please like us on Facebook so you can see all of the great information that we share and all of the webinars that we do. If you haven't applied, please apply online so that Jessiana can chat with you about your specific case, and we'll be able to help you directly. And then we also have a refer a friend program where you can earn $250 every time you refer a friend that has passed the NCLEX. So thank you everybody for joining us wherever you are in the world, and we hope that you have a fantastic rest of your day or evening.